Hello and welcome to episode 23 of our podcast on all things restructuring, No Worse Off. In the last episode, we kicked off our new sub-series, Hot Topics, the idea of which is to do a deep dive on a different jurisdiction in each episode. And I'm delighted to be back with the first of our jurisdictions, which is the Netherlands. I'm Lindsay Hinkston. I'm head of the London restructuring practice here at Freshfields and also one of your regular co-hosts. I'm delighted to be joined today by Amsterdam partner Michael Broders, who recently won the IFLR Europe Award for Netherlands Lawyer of the Year, and also Senior Associate Huub Bukhurst. So first of all, to kick us off, can I ask you both to introduce yourselves more fully and also to say a bit about our practice in Amsterdam? Maybe coming to you first, Michael.
Of course, and thanks, Lindsay. So I'm a restructuring partner based in Amsterdam, and I work on creditor-side mandates, company-side mandates, and sponsor-side mandates. And over the years I've been involved in some of the larger cross-border restructurings, closely working with you, for instance, on McDermott and Selecta. And on McDermott, I had the honor to be the court-appointed restructuring expert. And we've also worked on matters like Royal ESA and somewhat more distant in the past, Royal Imtech, which was a listed entity that went bust and then dragged on for 10 years or so. In the Dutch case, it was a pretty big event, that one.
And Huub?
And I'm a senior associate in the same team as Michael, also based in Amsterdam. And I work closely with him and the rest of the team on these matters. And I was seconded to the London R&I team last autumn, and it's great to be back for this occasion.
And it's great to have you back, Huub. We've been missing you. So look, thanks very much both for joining us. And to kick off things, let's set the scene on the Netherlands. So Michael, to start with, what are the general trends you're seeing in the Dutch restructuring market right now?
Yeah, so to quickly set the scene, I think it helps to spend a little bit of time on the jurisdiction itself, right? The Netherlands isn't a very open economy. It has always been like that. And a trading nation, so we have lots of kind of touch points with jurisdictions all over the world. We have a very wide net of tax treaties, but a combination of an open economy and that fiscal context means that we have large companies that operate out of the Netherlands, but we also have foreign companies that have holding companies in the Netherlands. So that kind of creates a combination of lots of larger sized domestic restructurings, but also very big cross-border international cases. So in that sense, the Netherlands is a little bit of a hub potentially for larger restructuring matters. And that's also what we've seen. With the introduction of our new restructuring tool in 2021, and since introduction, we've had the evaluation by the legislator about the inception of the new tool, the WOA. We've had a couple of really significant cases. For instance, Steinhoff, McDermott, I already mentioned, Diebold Nixdorf, which was a combination with the US Chapter 11. So right at the beginning already, we had really complex cases go through the Dutch process, reinforcing how the Dutch jurisdiction fits into the wider economy in Europe and more internationally.
And what about outside of formal in-court restructurings? There's been a lot of talk about LME.
Yeah, so that's a little bit of a trend, right, which I think you see across Europe. We've had this sprint of activity following the introduction of these new tools across Europe, in Germany, the UK, and people rushed to court almost to try out their new tool. And I think that has resulted a little bit in kind of a new trend where people are trying to achieve restructurings within the confines of a document, using intercreditors, ICA drag, combined with an enforcement. So that's definitely a trend that we're also seeing in the Netherlands.
We'll come back to the WOA and talk about that in more detail, but given it's the hot topic really at the moment, to zoom in briefly on LME, do you think the Netherlands is a particularly favourable jurisdiction for LME? Because obviously some of the big headline-grabbing cases, Hunkemuller, Selecta, have had a strong Dutch component. Is there a reason for that?
I think there actually is a reason for that, other than kind of what we just discussed, right, about the Dutch jurisdiction. We are an open economy. Lots of the financings in the Netherlands are English law governed. These are almost European cases in a way. But another, I think, a feature of the Dutch jurisdiction is that our legal framework is actually quite nuanced in a sense, but we actually have very open norms that therefore allow both creditors and company to apply their thinking to a particular situation. So what I'm saying is the legal framework lends itself for a little bit of creativity. So the director's duties norm, for instance, is an open norm. There are no filing triggers. So that allows a debtor some room to work with. On the other side, because we have these open norms, creditors that feel that they are disenfranchised actually do have quite a bit of tools to kind of check what the debtor has been doing in terms of LME type of transactions. And that's also what we're seeing happening in the cases like McDermott and Selecta.
What are some of the things that creditors can do in response to the use of some creative tools by the company?
So broadly speaking, we see three main ways for opposing creditors to try to challenge an LME via the Netherlands. And I guess the first one is the traditional fraudulent preference action. And contrary to many jurisdictions, you as a creditor can invoke that right outside of bankruptcy. So sending a letter that you challenge the transaction, and then as a matter of Dutch law, it is challenged. In Dutch, we call that actio pauliana, or in Latin, I should say. And the effect of that could be quite far-reaching because it could technically entirely unwind a specific transaction. Another key tool in the Netherlands is that we have a very flexible regime for levying in a pre-judgment attachment, which basically is a freezing order. You can obtain such an order without involving the debtor, ex parte proceedings, we call that. And then the third element is that we have a flexible disclosure regime. And we've also seen that play out in McDermott and Selecta, where the opposing creditors try to get their hands on specific information and go to court to get that information. And although it was rejected in both cases, that tool, that Dutch disclosure regime, could be an incredibly effective tool to create some nuisance value and to try to get information on what happened in the LME.
All right, well, in the interest of not turning this into another episode all about LME, which is what it often slips into, let's move back to talk a bit more about the WOA and how that's been developing since its introduction in 2021. As you've said, that's the equivalent of the UK restructuring plan in the Netherlands with the cross-class cram-down feature. So, Michael, what is it that makes the WOA attractive from a company's perspective? It's seen as a very debtor-friendly tool, I think.
Yeah, so there's quite a bit to unpack there, right? Let's touch upon the various elements which I do think make the WOA very attractive, which is it creates a stable platform for the company. And one of the features when you kind of are in financial distress and you would go to a court to have a formal process is clearly that it is out in the open that you are in financial distress. And that in itself can trigger further pressure from creditors, suppliers, which is never a good thing when you're trying to kind of turn around a business or adjust a balance sheet through a restructuring. Another important element of the Dutch WOA is, I think, its flexibility as regards the allocation of the surplus or the benefits of the restructuring. The WOA offers various levers to kind of really work towards a fair plan. Another element of why the WOA is particularly attractive is the fact that it's very cost efficient, certainly comparable when you compare it to the UK or the US. And there is another element that I would like to mention is the fact that there is deal certainty. And that shouldn't be understated, right?
All right, well, look, let's unpack some of that a bit more. And starting with the stable platform, and here I think it's definitely fair to say the WOA has got some bells and whistles that are lacking in the UK process, but maybe echo a bit more Chapter 11. What do you see as the main features that lend themselves to creating that kind of stable platform through the process?
There's several. Let me kind of first mention the ipso facto ban, the fact that whatever you write into your contract, whether it's a credit agreement, a joint venture agreement, or any type of contract with a supplier, and you would tie a termination right to the commencement of a WOA, that is in effect ineffective. So that means that you can maintain the value of the business, and it can even mean that lenders are required to continue to finance the business.
Also, a key feature is the fact that the WOA can be a private process. And when I say private, I actually mean confidential. You can do a WOA without anyone being aware of it, which is, of course, incredibly helpful for consumer-facing businesses that want to do a financial restructuring. And confidential in that context means a hearing behind closed doors, the WOA not being registered in any public register, and creditors only being informed on a need-to-know basis.
Another thing that we should mention in this context when we talk about stabilization of the business is the moratorium. Unlike in the US, we do not have a first day automatic stay, but we do have the ability to ask the courts to order a stay, which, by the way, will have automatic effect throughout the European Union. If you're talking about a business which has its COMI in the Netherlands. And I think the big differentiator with the US is that this stay can be very targeted. You can ask the court to order that the moratorium applies in relation, for instance, to a particular supplier, a group of creditors, financial creditors only, and therefore it's a very precise instrument. So it's one of the features that definitely help in stabilizing a business.
Very interesting, that idea of a selective moratorium. So maybe we'll move on then to one of my favourite topics around what you described as flexibility, but really the question of value distribution under the WOA and how it helps get to fair outcomes. Where do you think the WOA distinguishes itself on that?
If you would compare the Dutch process to, for instance, the US, which has a very rigid priority rule, the starting point in the WOA is the statutory waterfall. So value allocation needs to take place on the basis of the priority and the ranking as set out under the law. But at the same time, it is very clear when you read the legislative history, but also look at the many cases that we've seen by now, is that what the court is looking for is actually a fair deal. It seeks to establish, wants to be convinced by the debtor, firstly, that the debtor has tried to achieve a plan with its creditors and failing an agreement as a result of those negotiations. It will then test the plan against the statutory framework, but it will allow deviations depending on who or which stakeholder contributes to what to the reorganization or achieving the reorganization value. For instance, if an existing shareholder is necessary for the continuation of the business because you need an anchor investor, or if a particular group of financiers continue to stand behind the business, that will be a factor that will be taken into consideration when the value is being allocated amongst the plan. So many people actually are very worried about notions of fairness within the context of restructuring plans, be it a WOA or a UK a restructuring plan, and I'm clearly less familiar with the discussion in the UK. But I actually think that the notion of fairness is not necessarily something that people should be overly worried about. I think very often in practice, once you're putting a plan together against a backdrop of a sincere effort or push to come to some type of consensual deal with creditors, it will often be very clear what is a fair deal under the circumstances.
What's very linked to that, and which basically also evidences Michael's point, is that if all classes vote in favor, the Dutch court will not actually test the value allocation as such, right? If all classes vote in favor, there is no priority rule and no priority rule tested. The court will only assess whether each individual creditor is in a better position than in bankruptcy.
What's really interesting to me about all this is when we were going through McDermott, it felt like the English and the Dutch regimes were in quite different places on this question. And actually, as the English regime has evolved over the last 24, 36 months, I've benefited enormously from talking to both of you about how the Dutch regime works, because actually listening to you talk there, Michael, it starts from a different place because you have that guiding star of absolute priority, which we don't have. But actually, I think the thought process now is not as dissimilar as it was maybe when we were working on McDermott. So that probably brings us to the other topic, because, of course, one of the debates is, well, all this flexibility is marvellous, but where's the certainty? You mentioned that you think deal certainty is actually one of the advantages of WOA. So what makes you say that?
The Dutch legislator has very consciously introduced two features in the Dutch process. One is the fact that there is no possibility for appeal. And that sounds pretty binary, because if you're a creditor or a sponsor and you get disenfranchised as a result of the process, you have only one instance. So the fact that you have deal certainty as of sanctioning is a very powerful element of the Dutch WOA. So that in itself, I think, is a big difference with the UK and with the US.
The second issue, which more or less balances the point Michael made, is the fact that you can ask the court for interim decisions. So before you go to your final sanctioning hearing, you can already go to the court and ask questions like, hey, is this class composition all right? Is this value allocation all right? And would you court basically accept these fundamentals of the plan before you ask the court to sanction the plan? And why is that? Because at that point in time, you can still modify or change the plan to make sure that it meets the legal requirements for sanctioning. And that in itself reduces the execution risk considerably and can actually make sure that you can get deal certainty well in advance of the sanctioning hearing.
The point that Huub makes is quite important because practice in the Netherlands at least started off a little bit on the wrong foot in the sense that despite the fact that we have this beautiful tool where you can ask the court these questions, people were very reluctant to do so. Whereas the entire law was designated to actually involve a judge in complicated questions. And the practice did exactly the opposite. They tried to make everything binary for a court. And I don't think that courts like that. At some point, they will just push it back to you. So I think if you have a complicated problem in a matter where also there is no appeal possible, you should use the tools that you have in the law. And you should proactively, as a party in a litigation, try to kind of clearly set out to the court what the issues at hand are actually. So another point around deal certainty that we have in the Netherlands is that you have the ability as part of your plan to ask the court to confirm that certain aspects of your plan, be it new financing, be it a disposal, cannot be challenged afterwards, right? We are doing restructurings, we're having our plan sanctioned, but that's not a guarantee for a successful outcome. The business may still, unfortunately, fail in practice after plan confirmation. And it's exactly for that reason that the Dutch legislator introduced the possibility in the law to, at the plan confirmation hearing, have transactions effectively be safe harbored for challenges afterwards. And we've used that successfully in the Royal ESA case. And it's, I think, a feature that is somewhat undervalued as part of the Dutch ROA process.
Yeah, probably we try to get to a similar outcome through the use of releases through the plan, but we don't have a specific provision for it in the legislation in that way. And then finally, onto the controversial topic of cost effectiveness. So how do you think the WOA compares?
I think if you compare the WOA to a US Chapter 11 and even to a UK RP, it's much more cost effective. I think the process is not actually even a court process. You only go to the court at the sanctioning. So there's no case pending. You only file your application for confirmation and potentially your application for interim decisions or potentially your application for the moratorium. So it's effectively, and that's also how it was intended, a very light touch, informal process.
Another point we tend to overlook is that the Dutch legal culture is quite different from the UK or the US. And you, for instance, see that when you look at the concept of evidence. So in the Dutch ROA, we don't have formal witnesses. We don't have cross-examination. No formal burden of proof in the adversarial sense. No skeleton arguments, and not even barristers. So it's all very light touch compared to the English legal system. And much more, as Michael indicated, out of court, very informal.
Huub mentioned the fact that we don't have any formal evidentiary rules. It's correct that there is no official or formal evidentiary hurdle in that sense. And there I think the observer comes in, because the observer is a person that is appointed in every instance where there is a cross-class cram down. And I view that person as the guard keeper or the gatekeeper of due process within the ROA. They ensure that all of the parties impaired potentially by the plan have fair access to information. They provide guardrails for the valuation disputes. They may have their own independent valuator, which will often be a reputable financial advisor, Big Four. So that kind of makes up for the fact that we do not have discovery, but at the same time, it keeps the cost of the process very, very low. And by extension, we've seen SMEs, small businesses go through the WOA process. So in that sense, it really fits the bill.
It's actually akin to the company voluntary arrangement in the UK and this role of supervisor/nominee, which is there because that is largely an out-of-court process. There's court filings, but unless it's challenged, it never actually gets in front of a judge. And so you put it under the supervision of this independent...
Correct. Yeah, sounds very similar.
And people take comfort from that.
Yeah. So to kind of distinguish the expert from the observer, and I think the Netherlands is not unique in having an observer, right? Germany has a similar person in the Starug. But restructuring experts clearly has a much wider role. That person does have the ability not only to ask questions to the court, but also has the ability to offer a restructuring plan. That may sound very kind of scary if you're a debtor and you've kind of tried to, progress your own plan. One should remember that there's only been a handful of cases out of the 400 decisions where a restructuring expert has been appointed at the request of creditors. So it's really an exception, and the court will generally only appoint a restructuring expert at the request of creditors, particularly in view of the fact that there is no appeal possible, because they doubt that the plan that the company and its supporters are pushing will get confirmed. So it's effectively almost an emergency type of...
Like a saving provision.
Yeah, you're absolutely right. The law was changed, and the restructuring expert no longer has the ability to first offer a plan that it prepared. It must always, when requested, offer the company plan. So that means that the risk of competing plans or the risk of the restructuring experts dominating effectively the discussion, I think has been significantly mitigated.
So just to understand that, the restructuring expert doesn't put forward their own plan now?
They can, but they can only do so if the company doesn't prepare a plan or after the plan of the company has been put forward. So in effect, the company has the exclusive control over its own plan, and the restructuring expert must offer that plan to the creditors for a vote. Does that always mean that the company will be successful in offering a plan? No, not always, because if the company plan doesn't really work, which the restructuring expert can test by asking these questions to the courts, then we're back to the drawing boards. And I think that's when you can really have the debate around whether or not a plan needs to be adjusted.
From a company perspective, having this independent person appointed can also be super helpful in convincing creditors that the plan is actually credible and independent and works for everyone involved. So having this person appointed that can be a proxy for what is fair and what a fair allocation of value is can be very helpful for the company as well.
I quite like the fact that it's a single shot, because it does force all stakeholders to ultimately come up with a bargain that works and can get confirmed by the courts, for which it must be fair.
All right, so let's move on from the WOA and shift to something else that is back to being a hot topic in the market, I would say, after a few years of nothing but WOA. Share pledge enforcement making a comeback. Why do you think that is, particularly given what we've just been discussing in terms of the advantages of the WOA regime?
Yeah, in my mind, people got a little bit overexcited at the beginning of a WOA because the share pledge was always still there, right? And we used to do, for a long time before the introduction of the WOA, restructurings through share pledge enforcements, all the way back to Schuller, Arca, Lebara, HEMA, IAC, and there's a few more of those. So it's a fairly effective tool, albeit that in practice, there's different reasons for using one tool over the other. For instance, we talked about the various stabilization measures under the WOA, the moratorium, the ipso facto ban. The ipso facto ban you don't have in a share pledge enforcement, but the other differentiator is really the valuation. For a WOA, it's all about the going concern value, and for a share pledge enforcement, it's actually the enforcement value, which is the value of the shares as established by a professional valuator when taking into account effectively the fact that it is a distressed sale transaction. So a significant markdown in practice from the going concern value. That difference, leaving aside the practical implications around change of control, why one would kind of pick ROA over a share pledge enforcement, can have very significant implications for junior creditors. If you go for going concern and a ROA, it may be the case that junior creditors or even shareholders are still in the money on the reorganization basis. However, if you go for a share pledge enforcement and you have the valuation made by a financial expert that determines what actually enforcement value is, that may mean that junior creditors are wholly out of the money. So that difference, I think, can be quite an important driver for how a restructuring transaction ends up looking ultimately.
A way to conceptually think about that is that a ROA allocates value after a restructuring, so after a successful restructuring, whereas a share pledge, by definition, allocates the value before the restructuring, right? And that explains the gap between both systems. And I think there are also other reasons why a share pledge enforcement became attractive again. And for one, it's super fast, or at least can be super fast. We have seen cases where it was basically completed within 2 to 3 weeks. And although we would say that the ROA is fast, it's not that fast. And the second thing is that the legal test the court applies is narrow. It's an enforcement. So the court will simply test, is the offered purchase price the right purchase price, or can we obtain a better purchase price? And often with credit bids, that's obviously not the case.
Can you walk us through the mechanics of how the share pledge enforcement works in the Netherlands for those who haven't done one for a while?
Yeah, sure. In many jurisdictions, and also the Netherlands, the starting point for enforcement of assets, any assets, so also shares, is a public auction. You can also get consent from the Dutch court for a private transaction. So that typically involves the creditors providing a bid on the shares, which typically contains of, hey, I'm here willing to release my claims in exchange for getting the shares. So basically a credit bid that is pre-packed and will be approved by the court. And then the court only tests whether that offer is fair, which basically entails the question, is the existing shareholder or the junior creditors, are these parties out of the money? The real magic doesn't sit in the Dutch share pledge enforcement and also not in the court's test, but in the intercreditor. Because the intercreditor actually allows not only to disenfranchise the shareholder, but also other creditors. The intercreditor provisions provide for the distress disposal mechanism that allows the company that is being enforced over to be released from all security and all guarantees. And that in itself allows for a clean company to be acquired by the entity that acquires the business without any legacy liabilities. This also immediately shows you what the limitation is of a Dutch share pledge enforcement. If you want to bind creditors to a restructuring that have not signed an intercreditor with these distress disposal mechanics, then you simply cannot restructure them. So a Dutch share pledge enforcement, nor any other share pledge enforcement in the world, does not allow for an actual cross-class cram-down.
Yeah, so it's more a tool for dealing with financial creditors that have signed up to an intercreditor. And in this respect, all of that is very familiar from an English perspective. It's a tool to take the shares. You need to demonstrate fair value. You can credit bid. I think the biggest difference is probably, though, in the UK, you can do all of this out of court through the appointment of a receiver or an administrator out of court and a pre-pack. Whereas, obviously, as you mentioned, in the Netherlands, to do a private sale by way of enforcement, you need the court stamp. Is that a disadvantage, do you think?
No, I don't think so. It's actually an advantage. Why? Because the court process, and again, it's very swift. It also doesn't have a possibility to appeal. The purpose of the court hearing is to kind of have all the stakeholders in court and have them have their say on whether or not the execution sale is legitimate, whether it is indeed for the right price. And that is also what the court will test. And what you need for that process is evaluation by a reputable advisor, which shows that the price on offer is the best achievable price under the circumstances. And when you enforce and how you enforce, that's all up to the discretion of the security agents. And that valuation will also show that all junior creditors, all stakeholders that have been invited, are not harmed in their interests because they're out of the money. And that's exactly why you need to invite everyone to the party. Because if they're at the hearing, they have their day in court, and the court will either grant their objection or not.
So where did it go wrong on Selecta then, to the extent that that Dutch share pledge enforcement is being challenged?
There is, in effect, a prohibition on appeal following this enforcement process. And why is that? Because it was designed to be a very quick and efficient process. No appeals possible. There is one general exception in case law that allows you to break that prohibition on appeal, which is in effect a wrong application of the actual tool or an infringement on the principles of fair trial. One of the principles of fair trial, pretty important one, is the one for interested parties to be heard. And I think that's where the clue is in this particular matter. Point being, this all could have been avoided if they would have gone down the route to invite everybody to the party, which is, for a lawyer, it's a very counterintuitive thing to do, because you want to keep everybody out of the courtroom, you don't want any objections, but why would you be afraid of that when the test for getting your leave is actually so binary? In my mind, it's the same counterintuitive thing that you saw around the introduction of the ROA, where people didn't want to go to court to ask questions to the court, but just make it binary, which sounds very attractive, but actually it's not.
It's a really interesting point. I feel like we have this debate in so many different contexts in restructuring between, oh, but you don't want to give the forum for the opposition, but actually avoiding the forum isn't avoiding the opposition. It's just kind of giving you this overhang of challenge, potentially, that you could have avoided.
Trying to do that is pre-cooking post-restructuring litigation.
And post-restructuring litigation has arrived. Well, thank you very much to both of you. That's been a brilliant run through all things Netherlands. And thank you to the listeners. And if anybody wants to discuss any specific situations or any of the topics we've been covering, then obviously please do reach out to Michael Hoob or anyone else in the Freshfields restructuring team. Thank you again, and please tune in for the next episode of No Worse Off.